Suddenly, money, property, or what dad really wanted is driving a wedge through your family. Most inheritance disputes didn't start because someone is greedy. They start because people who are grieving, confused, scared, or feeling left out. A father dies, and before the family even gets a chance to grieve, the arguments start. Who's paying for the funeral? One daughter wants a big ceremony to honor him. Her brother is worried about the cost, and a third sibling is sure their dad would have wanted something simple. Meanwhile, the credit card bill for the deposit is due, and the funeral home is waiting for a decision. A time of mourning quickly develops into a bitter family feud, poisoning the very memory they're trying to honor. Here's what I want you to hear first before we talk about options or legal paths. This exact scene sadly tears families apart every single day, but it absolutely doesn't have to be this way. There's a legal role designed to prevent this kind of conflict and bring order to emotional chaos. Call the personal representative, the executor, or administrator. When you lose a loved one, your emotions are raw. Grief, stress, and shock create a powder keg where the smallest disagreement can set off a massive conflict. And there's no bigger spark than money. The average funeral costs a lot and an expense that shows up suddenly and needs to be paid now. Without a clear plan, the weight of these decisions lands squarely on grieving family members. So who has to pay? Here's a hard truth. Legally, no one is obligated to pay for a funeral unless they sign a contract with the funeral home. This leads to a few common and pretty destructive scenarios. Sometimes one child pays for everything up front, just assuming they'll get paid back. They're shocked to find their siblings disagree with how much money they spent. They end up feeling resentful, while the others feel pain for a service they had never agreed on. This is where financial pressure and emotional turmoil collide, creating family risks that can last for years. The arguments that start at the funeral home can echo through every holiday and family gathering, turning them into painful reminders of the fight. The real tragedy is that all of this is preventable. The solution is legally empowered role, the personal representative. So, what exactly is a personal representative? This person, who you might also call an executor or administrator, is appointed in a will or by court to legally settle the deceased person's estate. Think of them as the captain of the ship, hired to steer through all the messy legal financial waters after someone passes away. They are a fiduciary, which is a fancy legal term meaning they have a duty to act in good faith and in the best interest of the estate. Their job isn't to take sides or make decisions based on emotions. It's to follow the will and the law, providing a neutral, authoritative voice when everyone is distressed. They are the single best tool for stopping family fights. Why? Because they centralize authority. Instead of three different siblings making three different plans, you have one person who is legally empowered to act. This immediately solves the too many cooks in a kitchen problem. A personal representative just doesn't manage money, they manage conflict. They're a buffer between grieving relatives and the tough financial calls. The power doesn't come from being the oldest sibling or the loudest person in the room. It comes directly from the law, giving everyone a clear, fair framework to follow when they need it most. Next, let's look at the practical steps they take to handle costs and keep the family together. A personal representative doesn't just wing it. They follow a clear, legally guided game plan to make sure everything is handled fairly out in the open. If you're getting some value out of this and want to keep learning how to protect your family and your assets, do us a favor and subscribe. We put out regular videos designed to give you clarity and peace of mind on these really important topics. The person stuck in the middle didn't volunteer for this role. You were named personal representative, executor, or trustee, and now everyone is looking at you to handle it right. Up to this point, we've been talking about the role of personal representative, managing expectations, communicating clearly, and trying to keep the family together. And in many estates, that is enough. But sometimes, even when you do everything right, emotions run high, old wounds resurface, and the dispute doesn't resolve itself. When that happens, this is no longer just a family issue, it becomes a legal one. So now let's talk about your options when a dispute can't be resolved informally and how to protect the state and yourself. Section 1. Legal options when a dispute starts when inheritance disputes arrive. There are 3 legal paths they usually follow, and I'm going to be honest with you about all 3. Mediation. The best place to start. Mediation is guided conversation with a neutral third party. That mediator doesn't take sides. They don't make decisions for you. Their job is to help everyone be heard and work toward a resolution that keeps you out of court. Mediation saves time, money, and often family relationships. It doesn't mean everyone walks away happy. It does mean everyone agrees enough to move forward. Arbitration. Binding but still private. If mediation fails, arbitration may be the next step. An arbitrator listens to both sides and makes a decision. That decision is legally binding. There's no endless back and forth after that. What the arbitrator decides stands. It's more formal than mediation, but still faster, cheaper, and quieter than court. 3, litigation. No one plans for this. It's where the attorneys get involved on multiple sides, and this is where things get expensive fast. Lawsuits don't just cost money, they cost time, energy, and very often relationships. I've seen estates where legal fees consumed a shocking portion of the inheritance. Sometimes there's barely anything left to fight over at the end. That's why, whenever possible, mediation and arbitration are the smarter paths. Section 2. What beneficiaries need to know. If you're a beneficiary, here's what matters most. You have the right to see the will or trust, be informed about progress, ask reasonable questions. But here's the hard part. Probate and estate administration take time, sometimes years. There are legal fees, taxes, real estate costs, outstanding bills, and distributions that don't happen until all of it is handled. Section 3. What personal representatives must do. If you're the executor, administrator, or trustee, listen closely. You have a fiduciary duty. That means you must act in the best interest of the estate and all beneficiaries. A few non-negotiables: do not commingle funds. Document everything. Keep records of every expense and communication. If you mismanage funds or appear to, you can be held personally liable. This role is not just administrative, it's legal, and it's okay to ask for help. Section 4. How to reduce conflict before it explodes. Here's what actually prevents disputes. Regular family updates, clear expectation, written agreements, even informal ones, professional guidance, and attorneys, tax advisors, and experienced real estate professionals. And most important, communication. Inheritance disputes don't have to tear families apart, but silence, confusion, and delay often do. If you're navigating this right now, whether as a beneficiary or a personal representative, you don't have to figure it out alone. We create these videos to help families slow down, understand their own options, and avoid costly mistakes. Subscribe to this channel for clear, compassionate guidance on probate, estates, and inherited property. And if you need help walking through your situation, reach out. A short conversation can save months of stress. With the right information, you can get through it clearly, calmly, and with family relations intact. I'm not a lawyer or a tax professional. The presentations reflect my own understanding of the underlying subjects. However, presentation is based on my professional experience in the field of probate real estate. The information contained herein should not be used as a substitute for the advice of appropriately qualified and licensed attorney or tax professional.